Attorney Kevin Crayon here. This is a federal courthouse for a discrimination case that is going to a jury trial. Today, I just had a pretrial conference. This means that my case is going to a jury trial. And today, we met with the judge to determine what evidence is going to get in, what witnesses are going to get in, what evidence is excluded, how long the jury trial will last, what are the issues of discrimination that are to be decided, how are the damages going to be decided for a jury. But how did we get here? How did I get to this point where I am having a jury trial on a discrimination case? How does a discrimination case make it to a jury trial? In federal court, public win. You have to have a qualified lawyer specifically admitted to practice in federal court. Now, how did I get to a jury trial? There are different routes depending on if you're a federal employee or if you are a non-federal employee. If you are a federal employee, you first have to make EEO contact within 45 days of when you learned of the discrimination. Each federal agency has an EEO department. That's where you would make your EEO contact, informal EEO process, the formal complaint of discrimination process, and then the EEO investigation. At the end of that EEO investigation, you will be given a notice of rights. You could continue to pursue the EEOC hearing route, a right to have a bench trial, meaning a trial by judge, meaning that it's an EEOC administrative judge that will decide your case. If you're unhappy with the results, or if your case gets dismissed on summary judgment, then you may choose to appeal. At any point in that process, after a certain point in time, you can opt out of that system and file a complaint in federal court. And that's what I've done here. If you are not a federal employee, the way that you would start is you would still have to go to the EEOC, file a charge of discrimination. The EEOC will then decide whether they want to investigate or the extent that they want to investigate. They will get a position statement from the defendant, and you will have a chance to respond to that position statement. The EEOC may decide to bring the parties together for mediation, to try to reconcile. And the EEOC may decide to get more involved and actually file a suit on your behalf with your attorney. More often than not, the EEOC will issue a right to sue letter, which gives you so many days to file in federal district court, which is where I am now. So those are the two paths, depending on the type of employee you are, to get to federal court. Now, once you do file in federal court, you have to file the complaint alleging discrimination. You have to plead sufficient facts showing the discrimination. Then you have to actually serve the defendant. All of this is governed by the federal rules of civil procedure. It's very important that you actually serve the complaint in the proper way. Otherwise, your case could be dismissed before it ever really gets started. Once the complaint is served, the opposing party, the defendant, has an opportunity to file an answer. Usually their answer will deny the allegations. In federal court, you have to begin the process of automatic discovery. These are actually called initial disclosures. Rule 26 disclosures. Federal Rules of Civil Procedure, Rule 26. Without having to request it from the other side, you are automatically entitled to a list of witnesses, a list of documents, and other information. As the plaintiff, calculations and methodologies to the other side for your damages. So these are automatic initial disclosures. Rule 16 conference. You will have a conference with the judge, or you will submit an order to the judge for the judge to sign off on, which will govern the procedures going forward for discovery and summary judgment. Rule 26F meeting with opposing counsel. You have to meet with opposing counsel, the defendant, agree on a discovery plan, kind of work together and collaborate on proposing an order to the judge. Each courthouse will usually have some kind of template or form. The two parties submit their joint report to the judge, or their joint proposed order to the judge, and the judge will make whatever additions or edits, sign off on it, and then the discovery process begins. Before I go further into what is discovery, what is the law that governs civil actions? Federal rules of evidence, federal rules of civil procedure, the federal rules of appellate procedure. There's also case law, circuit courts of appeals that have many district courts under them. So when you're looking up case law to see what's binding precedent, to see how courts have ruled, it's usually good to look at the circuit that you are in. But what else governs? Each court will have local rules. Whatever the federal rules of civil procedure do not cover, the local rules will cover. And they may have specific requirements for how a case is governed, from the font size to the pleadings, which means the documents that you file with the court, for motions. So it's important to read the local rules. But what else governs? Each judge may have his own particular standing order, his or her rules of practice. So it's important to always look on the judge's website, or to look to see if the judge has filed a general order, to see if there is something that governs how this particular judge likes to practice in his or her court. What else governs? Another thing that you need to look at is whether the court in general has general standing orders that govern the rules of practice. So it's important to know the sources of law, the sources of procedure, federal rules of civil procedure, and the federal rules of evidence. After you submit a proposed Rule 16 order to the judge, the discovery process begins. And discovery is just where the parties exchange information, documents. So for example, interrogatories. Those are questions that you're asking the other side. Information, explanations, data, requests for production of documents. These are documents that you are requesting from the other side. I also like to ask for discovery so that I can avoid unfair surprise. Summary judgment briefing stage, a motion for summary judgment. If it's the defendant, they are asking that the case be dismissed because they are alleging that there are no material facts in dispute. You cannot prove your case, and therefore we do not need a jury. The judge can decide this case as a matter of law. Of course, we would respond to such a motion as we did here, and defeat such a motion as we did here, saying, no, judge, there are material facts that are in dispute. Here's the evidence, because at this stage you do have to produce the evidence to show the judge and attach as exhibits. And this can include witness statements and declarations, sworn statements, exhibits, anything that would show that this is evidence that you intend to use at trial. If you have an affidavit from a witness, that shows the judge that you are ready to have that witness come and testify at trial. There's enough of a factual dispute. The judge cannot decide a case on paper if there are factual disputes, if there are credibility issues. The judge cannot do that on paper and should not do that on paper. If it appears that there are enough factual disputes or credibility issues, or that a jury could find in your favor, then they have to send it to the jury. Sometimes a judge will partially grant the summary judgment and partially deny it, meaning that only some of your claims get through to a jury. So here we are now. I've passed those obstacles. I've gone through the EEOC proceedings, and we filed in federal court. We got through the discovery period. We got through the summary judgment period. Now we are on our way to trial because we just had our conference today. My next video will discuss what happens at a jury trial. Gotta go.